When people talk about gun control battles, most eyes turn to Washington, D.C. But right now, one of the fiercest fights in the country isn't happening in Congress. It's happening in Oregon. At the heart of it is Measure 114, a law that does two things. It bans magazines that hold more than 10 rounds, and it forces anyone who wants to buy a firearm to first obtain a state-issued permit. Now, on the surface, supporters call it common-sense reform. But peel back the layers, and you realize this law could reshape how the Second Amendment is treated across America. Why? Because if Oregon can get away with redefining what counts as a protected arm, or forcing citizens to ask permission before exercising a constitutional right, then other states will take that model and run with it. And the legal roller coaster has been wild. First, a trial judge struck the law down as unconstitutional. Then, an appeals court brought it back from the dead. And now, the state's Supreme Court is stepping in to settle the fight. This isn't just local politics, it's a showdown that could determine whether magazine bans and permit-to-purchase schemes become the new normal nationwide. So the real question is, will the courts defend the rights of law-abiding citizens, or open the door to even tighter restrictions? Let's break it down. Oregon's Measure 114 wasn't some minor tweak in firearm policy. It was one of the most aggressive gun control laws passed by any state in recent memory. It imposed two major restrictions. First, it required citizens to obtain a permit to purchase before they could buy a firearm. That meant extra training, fees, and background checks on top of what already existed. Second, it outlawed the sale and possession of magazines holding more than 10 rounds. Here's the problem. Those aren't exotic, high-capacity magazines, as the media likes to call them. They're the standard equipment that comes with the most common firearms in America. A Glock 17 pistol ships with a 17-round magazine. An AR-15 rifle typically comes with a 30-round magazine. Under Measure 114, both became illegal overnight. The backlash was immediate. Gun owners, dealers, and constitutional scholars pointed to Article 1, Section 27 of the Oregon Constitution, which explicitly protects the right to bear arms. For decades, Oregonians purchased firearms without a state permission slip. Now, they were being told they'd need government approval to exercise a right they already had. Critics argued that this wasn't safety reform at all. It was an attempt to redefine the Second Amendment at the state level. And the practical concerns were just as serious. Data from the CDC and FBI show that the average number of rounds fired in defensive gun uses can vary. And while many incidents involve just a few shots, there are countless documented cases, especially with multiple attackers, where 10 rounds simply wouldn't be enough. Law-abiding citizens would face arbitrary limits, while criminals who ignore the law would keep their 15, 20, or 30-round mags. At trial, Judge Robert Rascio took a hard look at the evidence. Expert testimony showed that the supposed public safety benefits of Measure 114 were exaggerated, speculative, and unsupported by hard data. Crime trends in Oregon didn't match the narrative. In fact, law enforcement testimony highlighted that criminals were sourcing illegal guns and parts outside the regulated market anyway. The judge issued a permanent injunction, striking down the law entirely. For a moment, it looked like a clear win for gun rights in Oregon. The state of Oregon didn't waste a minute after Judge Rascio struck Measure 114 down. They filed an appeal, determined to save the law at any cost. And when the case landed in the Oregon Court of Appeals, things flipped. In a unanimous opinion, the appellate judges upheld both the permit-to-purchase system and the magazine ban, calling them reasonable regulations that balanced individual rights against public safety. Here's where the legal gymnastics began. Under Oregon's constitutional framework, the courts apply a two-step test. Step 1, decide whether the item in question even qualifies as arms. The state argued that magazines aren't arms, they're just accessories. It's a clever argument, but a dangerous one. Without a functioning magazine, a semi-automatic firearm can't operate as designed. To claim a magazine isn't part of the arm itself is like saying the First Amendment protects your right to print words, but not your right to use paper or ink. Step 2. Even if magazines are considered arms, the state says it can restrict them if it serves the public interest. This balancing test allows courts to weigh constitutional rights against vague safety claims. And predictably, Oregon leaned hard into this, arguing that fewer rounds equal fewer deaths. But here's what they don't like to talk about. The trial court already examined those claims and found them inflated. Expert witnesses testified that magazine limits wouldn't stop mass shootings and that criminals could easily ignore the law. FBI crime data back that up. Rifles of any kind, including AR-15s, account for only a few hundred homicides nationwide each year. Limiting law-abiding citizens' access to standard magazines doesn't address the root of crime. It only handicaps people defending themselves. The appeals court brushed aside that evidence, siding instead with a narrative of reasonable regulation. That ruling didn't just reinstate Measure 114, it created a dangerous precedent. It suggested that courts could carve out exceptions to constitutional protections whenever the state argues it's for safety. And once you open that door, where does it stop? Today, it's magazines. Tomorrow, it could be semi-automatic rifles. After that, maybe handguns altogether. For gun owners, the message was clear. Oregon's government was willing to push the limits of constitutional interpretation, and the courts were willing to help them do it. Now the battle has climbed to the Oregon Supreme Court, with oral arguments already scheduled for November 6th. This isn't just another case on the docket. It's the test of whether a state can force citizens to beg for permission to exercise a constitutional right, and whether it can redefine common, everyday equipment as contraband. The stakes couldn't be higher. If the Oregon Supreme Court sides with gun owners, Measure 114 is dead in the water. That would reaffirm that standard capacity magazines and the right to purchase firearms without a government-issued permit are protected under Oregon's Constitution. A ruling like that could ripple outward, fueling lawsuits in states like California, New Jersey, New York, and Illinois, where similar bans have been justified with the same public safety rhetoric. And make no mistake, such a decision would be attractive to the U.S. Supreme Court, especially after Heller and Bruen already made it clear that commonly owned arms are protected. But if the court upholds Measure 114, the damage will go far beyond Oregon. It would hand the gun control lobby exactly what they've been waiting for: a legal blueprint to copy nationwide. Legislators in blue states would point to Oregon and say, "See? The courts signed off on magazine bans and permits. We can do it too." Once that precedent is set, it becomes exponentially harder to roll back. And here's something worth noting. Oregon's High Court does lean left, but it hasn't rubber-stamped the state's every move. Earlier in this case, the court actually rejected attempts by the government to lift the injunction prematurely. That shows at least some hesitation. Still, we can't ignore the political tilt. The final ruling could go either way. Think of this as a flashpoint case. Not about 10 rounds versus 30, but about whether constitutional rights can be eroded piece by piece under the banner of public safety. If Measure 114 is upheld, it tells every lawmaker in America that the Second Amendment is a speed bump, not a barrier. And once rights become negotiable, they're no longer rights. They're privileges granted or revoked by the state. So here's the bottom line. Oregon's Measure 114 isn't just a state issue. It's a national test case. If the courts allow it to stand, then no right is safe from being balanced away in the name of safety. And if magazines and permits can be restricted today, what's stopping lawmakers from going after rifles, shotguns, or even handguns tomorrow? This is why every gun owner in America should be paying attention. Because what happens in Oregon won't stay in Oregon. Other states are watching closely, ready to copy-paste this playbook the moment they can. Now I want to hear from you. Do you think the Oregon Supreme Court will defend the Constitution and strike down this law? Or will they greenlight one of the most aggressive gun control measures in the country? Drop your thoughts in the comments below. We'll be covering every step of this case as it develops, so make sure you like, subscribe, and share this episode to keep more people informed. And as always, stay sharp, stay free.